will my charges be dismissed if I refused? And the answer is the refusal in and of itself, where you've not given a breath or blood sample, is a consideration in both DMV, at NC DMV, as well as in court. The refusal actually in North Carolina, under the North Carolina DWI laws, can be viewed as a negative inference, meaning the finder of fact, whether it's a judge or a jury, is allowed to consider the fact that you willfully did not give a blood, breath, or urine sample. Sometimes people have a problem with that, thinking, compulsory evidence against yourself and you have a right not to be incriminated. In North Carolina, refusing a blood, breath, or urine test is not a criminal charge, but it can have consequences and adversely affect your case. So if you refuse, is your case automatically thrown out? Is your case automatically dismissed? No. It depends on the facts and circumstances of the case. Clearly, without a blood, breath, or urine sample, that's one piece of evidence the state may not have available. But North Carolina can prove you guilty in more than one way, and it's not just with a reading. There's something called the appreciable impairment prong. Prosecutors, defense lawyers, DWI lawyers will refer to it as appreciable impairment. They can go in and just say, based on my training experience, I'm a police officer, I observed this person, I noticed red glassy eyes, slurred speech, odor of alcohol, they did poorly on standardized field sobriety test. In my opinion, they were appreciably impaired. That's enough. They can take that together with your willful refusal, and you can be found guilty of driving while impaired. Does that mean you are always found guilty? No. Each case is different. This is why, as a DWI defense lawyer, it's frustrating when well-meaning friends and family say, if you refuse, you automatically get a dismissal, or if you refuse, you're automatically found guilty. It's just not the case. Each case is different, each case is unique, and each case takes careful consideration of all the facts and the totality of the circumstances. That's how they train police officers to handle DWI cases. They consider the totality of the circumstances. That's what the court considers. And that's what, as DWI defense lawyers, we consider in providing legal representation. If you have questions, if you want to know the best case and the worst case scenarios, what are you looking at? Am I going to go to jail? Are my charges going to be dismissed? I have a clean record. Can I get a dismissal? Call us. We'll answer your questions. We don't charge for consultations, and I'd love to hear from you. Telephone number is 704-342-4357.